Good afternoon, everyone.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon.
Afternoon.
All right, we're ready to start.
Judge, if I might just have a quick second, I just wanted to introduce a new attorney with our office, Kaylee Wills. So just wanted the court to be aware that she's on the call today and she'll be assisting.
Okay, I see her picture. There she goes. Okay. Hi, welcome aboard. Nice to meet you.
Nice to meet you as well.
This is the most excitement you're going to ever have. We try to make it exciting anyway. There's never a dull moment, I can assure you of that. And I see Mr. White is there.
Yes, Your Honor. Good morning.
Good morning. Good afternoon.
Well, good afternoon. You're right.
I'm going to mess with you a little bit. Is that a real background or a fake background?
That's a real background. It's
So we should be jealous, and we are.
okay. I wouldn't like to make an announcement. Mr. Hadley is going to be accepting the state's offer of time served. So as you're aware, we won't be able to represent him for that.
Okay, let's see. Hadley. Oh, he must be on the add-on. Let's see.
I believe
Yes, number one on the add-on is going to be a solo plea.
That's correct.
All right. And Miss McLeod, they put, let me pull my other little calendar. They put your person on?
Mr. Horton, Your Honor.
Yes. Horton, hold on.
And I do need a moment to speak with him, Your Honor.
All right. I don't know. Let's see. Can we, who's my Zoom master, Miss
Champion.
Miss Champion. Can you, let's see, can we coordinate that so that Miss McLeod can talk to Mr. Horton?
Yes, we can, Judge, once we find out where he's located at the jail at.
Oh, okay, you're right.
Yes, Your Honor, there was an issue with them finding him earlier when I had called down there.
Okay. Deputy in courtroom 2, or can you all hear me?
Yes, ma'am. We will get him, but it's going to take some minutes. We will try.
Okay. Okay, take a second. Okay,
Yes,
so that he can talk to Miss McLeod, make sure what we're doing before we go forward. All right, we'll get started. Any other
Your Honor, just quickly, for position 8, the state is going to be requesting that that case be heard at the end.
Okay, let's see. All right, Mr.
Your Honor,
Ray will
actually,
hold
I
that
asked for a breakout room for MH issue for that case, Your Honor.
Oh, okay. Well, we'll do all of that at the end.
And we also need a Spanish interpreter.
Yes.
Uh-oh. Let's see, I don't, I believe Mr. Jordan said earlier that he requested one for the previous calendar. Ms. Bridgewater, check on that, or Ms. Champion, one of you all to make sure. Sometimes she'll sign on, you know, afterwards if she's in another courtroom. But let's make sure we have the Spanish interpreter coming.
Okay.
I believe he did, but I don't want to say for sure. All right. Ladies and gentlemen, I am Judge Regina Mincy, and we're going to start our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before state court judge, so we are able to address several matters, including bond, possible arraignment, and also a possible plea offer if one has been made by the state at this juncture. I'm going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Also, I want to remind the defendants on this calendar that you do have certain constitutional rights. The first being that you have a right to an attorney to represent you at this juncture. Most of you should know who your attorneys are at this point. You also have a constitutional right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be held against you. The solicitors are here and they're listening. So follow the lead of your attorney. All right. Let's see. Did you tell me? I'm looking in the chat. Ms. Bridgewater, what's our reset date?
April the 6th.
Okay, 4/6. All right, April the 6th. Thank you very much. All right, who do we have first, Deputy?
Position 2, Ms. Blake.
All right. This is case number 23 CR 001766C. Is it Isis Blake? You're charged with 1 count of criminal trespass, offense date March the 22nd, 2023. Pretrial.
I got first arrest. She
Okay.
recommended.
All right.
All right.
State.
Yes, Your Honor. This incident occurred yesterday, March 22nd, 2023, when officers responded to the Economy Hotel located at 9995 Old Dogwood Road. There they met with the manager who had made the 911 call, stating that he had received numerous noise, smoke, and smell complaints from other tenants coming from one of the rooms. Upon entering that room, the officers found the defendant and had recognized the defendant as the defendant was previously issued a criminal trespass warning from that same hotel on December 3rd of 2022. Your Honor, the state did send a plea recommendation to the public defender's office today, and we did not receive a response. So for that reason, the state is going to recommend a $2,000 signature bond, a stay away order from the Economy Hotel located at 9995 Old Dogwood Road.
All right. And is this your case, Mr. White?
It is, Judge.
Okay.
We have no issues with the signature bond, obviously. I would like to point out that the hotel is under a new company management. So I'm not exactly sure that the criminal trespass follows from one entity to another. She did inform them when she gave them her full name when she came in. The officer made the arrest based on former knowledge of the criminal trespass warrant. Just wanted to put that out there, but
Mhm.
She knows she can't go back at this point, and we have no problem with that.
Okay. All right. So I'm going to go ahead and issue the $2,000 signature bond. And let me ask this to determine whether I do this through pretrial or the jail. Do we have any residential challenges at all? Or is it just she happened to be at the Econo Hotel?
But she just happened to be there. She is employed and makes a decent living. She will not qualify for our services going forward. So,
Oh, okay. Okay. Well, I'm going to do it through pretrial services, that $2,000 signature bond through pretrial. And I am going to order no drugs, alcohol, or weapons while on bond. And I think that's all. Anything else, counsel, I need to take that?
Nothing further from the state, Your Honor.
Okay.
that's Judge.
All right.
No,
thank
stay away.
Oh, I'm sorry. Thank you. Yes, yes, yes. Stay away. Stay away. I'm going to order that stay away from the Econo Hotel at 9995 Old Dogwood Road. Thank you.
Thank you, Your Honor.
All right. Thank you. What do we have next?
Position 9, Ms. Sonia.
All right.
Chantel. Sonia.
This is 23 CR 0017776C. Chantel Sanye. You're charged with 1 count of simple battery, family violence, offense date, March 21st, 2023. Pretrial.
Hold on, I got the wrong file. Hold on real quick.
Okay.
All right. She got 4 cycles in her history.
Okay.
2018 suspended license. It was amended to driving without a valid license, NOLO. 2018 shoplifting arrest. 2018 probation. 2018 FTA for shoplifting. That's it.
All right. State.
Yes, Your Honor. This incident occurred this past Tuesday, March 21st, when officers responded to 1484 Chattahoochee Avenue, which is the workplace of the victim in this case, Ms. Shakaya Epps. That is SHAKAIYAH. There, they learned that earlier that day, Ms. Epps and the defendant, who was her girlfriend, had a heated argument at her place of residence. And Ms. Epps left the residence to go to her job, which is the incident location, the 14884 Chattahoochee Avenue. As Ms. Epps was getting out of the car in the parking lot, she heard a voice behind her yell, "Give me the keys, bitch," and turned around, and it was the defendant and the defendant's parents. The defendant then grabbed Ms. Epps and slammed her against her vehicle, causing her to hit her head, and then proceeded to punch her multiple times. A witness in the parking lot that had witnessed the incident tried to intervene and get the defendant off of Ms. Epps and was threatened by the defendant in the midst of it. Ms. Epps was able to get away and call 911. Your Honor, we do have concerns, as this was 2 days ago, for Ms. Epps' safety, and for that reason, the state is recommending a $4,000 surety bond, a no further contact with Shakia Epps, a stay away order from that incident location, 1484 Chattahoochee Avenue, 1 day anger awareness, and no drugs, alcohol, or weapons. We did reach out to Ms. Epps and were not able to get in contact with her, but I would ask to sound for her at the appropriate time.
All right. Ms. Epps. Shakia Epps, are you on the Zoom? Don't know that I see anyone with that name. All right. PD. Wills?
Ms. Sonier does reside at 497 West Street in Forest Park, along with Ms. Epps. She does not have any children. She does have longstanding ties with Georgia. She has resided here in the state since 2006. She has family and friends who live locally. She is employed. One job is a work from home job. Her other place of employment, she works as a property manager for the properties that her parents manage. She has a high school diploma. And she does deny the state's recitation of alleged facts, which are not yet in evidence, and does state that this incident occurred out of self-defense. And she is requesting a no violent contact provision for her bond. And we were asking for a $500 bond. And she does share a residence with Ms. Epps, as I did state before. So that would be my request of the court today.
Okay.
And Your Honor, if I may briefly, all of the facts that I just provided are in the warrant. Additionally, we would ask for a stay away in accordance with the no further contact with Ms. Epps from that residence to ensure her safety.
Okay. All right, I'm going to order the $4,000 surety bond. I'm going to order a stay away from 1484 Chattahoochee Avenue. And I don't have the residential address, but with no further contact with Shakaya Epps, which is what I'm going to order, then Ms. Sonier will have to find somewhere else to stay. Don't want her to reside in the residence that they share. Hold on one second. Excuse me. I don't want her to reside in the residence that they share together. No further contact. I'm going to order a one-day anger awareness course. And no drugs, alcohol, or weapons while on bond. So if they provide, well, I do have the other address, the 497 West Street in Forest Park. So that
Yes.
would be the other address, correct?
Yes, Your Honor.
Okay, so stay away from both addresses. And then we'll check all boxes on the order, the bond order. No contact through social media, third parties, emails, telephone, stay 200 yards away, and make sure that the victim will be safe.
And Your Honor, can we ask for a one-time police escort so that Ms. Sonier can collect her belongings at the residence?
Yes, and I will order that she have a one-time law enforcement escort back to the location in Forest Park to retrieve any personal items that she may have. And remember, it must be police escorted, not to go back alone. And I think that's it. Anything else, counsel?
Nothing from the defense.
Okay.
Your Honor, the Spanish interpreter is now on, so I don't know which case and what public defender that needed to speak with the Spanish interpreter.
Oh, yes. Which case was that?
Position 4,
And that's my case, Judge.
not
So-
4.
Okay.
Position 3, Herrera.
Oh, 3. Okay. If you can set them up somehow.
Yes. He can call courtroom 2. You have the number? So-
We're gonna need a breakout room with the attorney and the Spanish interpreter and the defendant.
Oh,
So is it possible that it can be moved to courtroom 3 or?
he can, but I'm the only one in here right now. so
Okay, that's fine.
I'm waiting on. Officer Norris to come back.
Okay,
Okay.
just let me know when you guys are ready.
Yes, ma'am.
Okay,
All
that
right.
sounds good.
You good.
All right.
We can go to position 10, Ms. Stevens.
Okay. This is 23 CR 001763E. Ms. Stevens charged with 1 count of battery, offense date March 22nd, 2023. Pre-trial.
I got a
Okay.
bunch of papers stacked up right here. Right the hell, Stevens? Let the state do it. All right, Stevens. Judge, I defer to the state.
Defer to the state. All right, Ms. Dillingham.
Yes, Your Honor, I do have this as the first offense. As
Okay.
in the GCIC.
All right.
Your
And
Honor,
go ahead.
this incident occurred yesterday, excuse me, March 22nd, when officers responded to 332 Adele Street Southeast. There, they learned that the victim in this case, Mr. Travion Hodge, and the defendant, who were in a relationship, were in a heated argument, which escalated to become physical when the defendant hit Mr. Hodge in the face. Upon arrival, officers did observe a laceration to Mr. Hodge's face. And we did reach out to Mr. Hodge, but we were unable to get a hold of him due to this incident occurring yesterday. There has not been a sufficient cooling off period, and thus the state feels that no further contact and stay away order is necessary. Accordingly, the state's recommendation in this case is a $3,500 surety bond, no further contact with Mr. Travion Hodge, 1 day anger awareness, and no drugs, alcohol, or weapons.
All right. PD Wills.
Yes, Your Honor. Ms. Stevens resides at 332 Adele Street, Southeast Atlanta. She was residing there with Mr. Hodge. However, she reports that she intends to relocate and terminate her lease from that apartment complex. She has resided in Georgia. And I'm sorry, I'm not sure if that's an apartment, but from her residence. She has resided in Georgia for the past 7 years. She has been employed or is employed and has 2 jobs. One is with the Veterans Hospital. The other is at a nursing home facility. Ms. Stevens has a high school diploma and reports that she is enrolled in HCI's nursing program. As it was stated, she does not have any criminal history. And Ms. Stevens denies the state's recitation of alleged facts and states that this incident did occur out of self-defense. She also reports that she is no longer in a relationship with Mr. Hodge and is requesting that they have no violent contact. And in light of Ms. Stevens not having any criminal history, we are requesting a $500 bond.
Okay. I am going to order a $3,500 signature bond through pretrial. I'm going to order stay away from 332 Adele Street Southeast. I'm going to order no further contact with the victim, Travion Hodge. I'm going to order a 1 day anger awareness course. I'm going to order no drugs, alcohol, or weapons while on bond. And I will allow a one-time law enforcement escort if she needs to go back to retrieve any personal items. And I'm assuming I didn't hear anything about any kids involved, right?
No, Your Honor, she does not have any children.
Okay. All right. Anything else I need to take up, counsel?
Nothing further from the state.
All right. Thank you.
Position 6, Mr. Perkins. Yes, ma'am. Okay.
All right, this is 23 CR 0017771A. Bobby Perkins, charged with 1 count of battery, family violence. Offense date, March 22nd, 2023. Pretrial.
He got 24 cycles. Appears to be on probation and card for robbery. 2016, they gave him 8 years probation for that. Last arrest was back in December. Probation violation. 2020 driving without a valid license, NOLO. 2020 probation. Given false name conviction from 2019. 2019 probation. Another 2019 given false name conviction. Before that was the robbery in 2016. Probation violation 2014. Possession of a firearm by convicted felon 2014. That was a conviction. 2013 probation. Another 2013 probation. What we got? Another probation from 2012. I needed it.
Okay. All right, state.
Yes, Your Honor, in this case, as pretrial has stated, this defendant has several probation violations and revocations. I also saw an additional 2012 simple battery and aggravated assault that was dismissed. In this case, it occurred on yesterday. Officers were dispatched to 195 Chickamauga Place. That is spelled CHICAMAUGA. Place Southwest. The caller was the victim in this case, Miss Rochelle Summers. That's ROCHELLE, Summers, common spelling. She indicated to officers that she was attacked by her daughter's boyfriend, the defendant in this case. It was further indicated to officers that there was an ongoing dispute in the house about who had left the gas stove on, and the defendant in this case came into her room after her husband had left from work and said that he wanted her out of the residence, and he grabbed her, pulling her, causing her shirt to rip, and grabbed her by the arm, also causing visible bruising on her arm as well as her shirt to rip, and scratches on her left arm as indicated visible by the officers at that time. There were some audio recordings of what was going on in the incident, Your Honor, but given this defendant's history and based on the fact that this just happened yesterday and that all these parties live together, we do have some concern about the risk of reoffense in this case. We have concerns about the flight risk in this case, given that this defendant has several probation violations. We are concerned that he may not show up to court, and also gives rise to our concerns about the likelihood of positive response to the legal process. This defendant has continued to commit crimes while on probation. For these reasons, the state is going to be requesting a $3,500 surety, no further contact with the victim in this case, Rochelle Summers. Stay away from the incident location as stated on the record. 1 day anger awareness, no alcohol, drugs, and weapons, no further violations of Georgia law. And we'd like the court to sound for the victim if possible. My office was not able to make contact, but she may be here, so we would like the court to sound for her.
All right. Rochelle Summers. Rochelle Summers, are you on the Zoom? Nope. All right, we'll go ahead. Is this your case, Speedy Wills?
Yes, Judge.
Okay.
Mr. Perkins does reside at 195 Chickamauga Place, which was the incident location. He states that he is the resident along with his girlfriend of that property, and that Miss Summers, his girlfriend's mother, as well as her husband and son were residing in their home, and that prior to this incident, A TPO and a notice of eviction was filed against Ms. Summers and her family members. Mr. Perkins has no objection to a no contact provision with Ms. Summers, and also denies the state's recitation of alleged facts. Mr. Perkins reports that Ms. Summers should actually be out of the property as of now, that she has plans and intends to relocate from his residence. And so we would ask that Mr. Perkins be allowed to return to that residence as it is his home, where he pays the rent. He is employed as a mover by H Logistics. And he is from Georgia. He has family and relatives and friends who reside here. His probation officer out of Carroll County is aware of this arrest, and he states that he is unable to afford bond at this time. He hopes to be released as soon as possible so that he can return home. He does also have a 7-month-old and 8-year-old child that reside in the home with him that he works to support. If the court is not inclined to not issue or give no bond or signature bond, we would ask a $1,500 bond, Your Honor.
And Your Honor, in this case, I do not currently see any TPO or eviction proceedings pending for this particular victim in this case, as the warrant indicates that this victim does live at that location. And as the PD has stated, we would request for that no further contact and that stay away, given that this did just occur. Nothing further from the state.
How old is Mr. Perkins? PD Wills?
He is, I'm sorry. He was born in 1990, so he is 32.
Yeah, 32. And you stated that he is working.
Yes, Your Honor. He is a mover for H Logistics.
Let me see. I'm a little concerned on the address. But I heard someone say that he had started, or maybe you said that he started eviction proceedings, but then ASG Duncan says she doesn't see any on record that has been filed.
Mr. Perkins reported to me that his girlfriend, and again, that is his girlfriend's mother that the incident occurred between, that his girlfriend had initiated eviction proceedings, and that it was Mr. Perkins, his girlfriend, along with his 7-month-old child and 8-year-old child who resided in the residence, and that Ms. Summers, her husband, and her son moved in within the past couple of months. But it was also reported that they were moving out today.
Given that we weren't able to speak with Ms. Summers, Your Honor, we understand the defense's contentions. However, out of an abundance of caution, we just ask for that no further contact and stay away. And if those proceedings come to fruition at a later date, defense is welcome to make any necessary motions to amend whatever the court decides to recommend for this defendant's bond.
Yeah, I just want to be sure. So I'm going to order $3,500 surety bond. I'm going to order a stay away from 195 Chickamauga Place Southwest. No further contact with Rochelle Summers. I'm going to order no drugs, alcohol, or weapons while on bond. And you can request an amendment if, or modification if it's later discovered that they have vacated the premises, or that the victim and her family have moved out. But I want to err on the side of caution since it just happened, and to make sure that they have moved before I order that he can go back to those premises. So right now, let him stay somewhere else until we can get all that sorted out. And so $3,500 surety bond is what I'll do.
And Your Honor, can he have a one-time police escort to retrieve his belongings?
Yes, I'll give a one-time law enforcement escort to retrieve clothing and belongings. And remember, Mr. Perkins, you're not to go back there alone, but get a law enforcement escort. That's it. That will conclude this case.
Thank you, Judge.
Mhm.
Position 4, Mr. Landry.
Okay.
Hey, yo, we see it's about that. Hold on.
Judge, who was next?
I think it was 4, Landry. But,
Landry?
uh-huh. Are they
I think they're waiting on you.
waiting on me now? Because I noticed he muted. Didn't know if he was
Yes,
handling
we're waiting on
something. Okay, you ready? Okay. All right, this is 23 CR 001769G. Mr. Landry, charged at 1 count of theft by 2 counts of theft by taking. Offense date March 22nd, 2023. Pretrial.
18 total. No, he got an open theft of lost miscellaneous property, reckless conduct, misdemeanor possession of marijuana. That's out of state court. 19 CR 007 624G. Open possession of a controlled substance, possession of drug-related objects. 23 CP 216459. Also appears to have open robbery in Clayton County and an open battery. 2021 trespass conviction. 2020 failure to appear. 2020 CWAC charge conviction. 2019 FTA. 2018 shoplifting. 2017 theft by taking, and 2016 failure to appear. That's it.
Your Honor, I don't want to interrupt, but however, this case is for Tom White's case. He's representing, but I think he is in breakout room for Spanish interpreter case.
Oh, shoot. Okay.
Can we do?
Thank
So
you
you
for
gonna-
that.
You wanna let me read all of that?
I didn't want to interrupt. Sorry.
I know. You can interrupt him because he's going to get you for later now. Let's see. Sorry, Deputy.
That's okay. We can go to position 12, Mr.
Okay.
Wells. We'll come back.
This is 23 CR 001775H. Khalil Wells, charged with 1 count of battery and a 2nd count of criminal trespass, damage to property. October 31st, 2022 is the offense date. Pretrial.
4th arrest. 2016 reckless conduct conviction. That's it.
Okay. State.
Yes, Your Honor, this incident occurred October 31st of 2022 when officers responded to 6805 Peachtree Dunwoody Road, which is the residence of the victim, Miss Chloe Grant. There they learned that an argument regarding the Ms. Grant and the defendant's relationship escalated and became physical when the defendant grabbed Ms. Grant by the throat and slammed her against the wall. The defendant also kicked in her front door, damaging the frame, kicked in her bathroom door, leaving a significant hole. And Ms. Grant did inform officers that the defendant had been heavily drinking. Officers also observed scratches and lacerations to Ms. Grant. Your Honor, due to the severity of the nature of this crime, the state's recommendation is $5,500 surety bond. That's $3,500 on the battery and $2,000 on the criminal trespass damage to property, and no further contact with Ms. Grant, and no drugs, alcohol, or weapons, as well as a stay away from that 6805 Peachtree Dunwoody Road. The state did have a chance to speak with Ms. Grant, and she did state that although that she is not afraid of the defendant, however, the state does have concerns of them continuing to reside at the same place due to the nature of this crime. I do believe Ms. Grant is on the Zoom, so I would sound for her at the appropriate time.
All right, Ms. Chloe Grant. Chloe Grant.
Yes, I'm here.
Yes, would you like to address the court today?
Yes, I can.
All right. Raise your right hand for me. I'm going to swear you in first. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. What would you like to state?
That since this incident has happened, we have moved past it. We are still together. That was the one and only time that's ever happened. I don't feel that he's actually violent. I just think maybe he was drinking too much that particular day. And I just would prefer no violent contact, but yeah, we're still together.
All right. And any cross-examination by Ms. Dillingham?
No, Your Honor.
Cross-examination by P.D. Kim?
No, Your Honor.
All right.
Yes, Mr. Wells is 27 years old and he was born and raised here in Georgia. They reside together. They do not have any child together. My client is gainfully employed at Home Depot, receiving department, and he also has associate degree. He has been working hard. Your Honor, we would like to request for a signature on bond because he did not have any other violence case in the past. And this is kind of one time, very remote case. This happened about 5 months ago, maybe more. So we would like to request for no further violent contact and signature on bond. Thank you.
All right. And I do understand that this offense date is October 31st and that the parties have been hopefully living together peacefully since then.
Yes, Your Honor.
I'm going to order a $5,500 signature bond through the jail. I'm going to order no further violent contact with Chloe Grant. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order a one-day anger awareness course. And I think that's all I'll order at this point.
Thank you, Your Honor.
Okay.
What was the breakdown, Your Honor?
Oh, I'm sorry. That would be $3,500 on signature on the battery and $2,000 signature on the criminal trespass.
That the SOB pre-trial,
I'm sorry.
SOB pre-trial.
I said SOB
Jail.
jail.
Yes.
Since he
Okay.
has a job and good conduct, yeah, that'll be jail.
Okay, no problem.
Position 11, Mr. Thomas.
Okay. This is 23 CR 001767B, Rodney Thomas, charge of 1 count of battery, offense date March 22nd, 2023.
He got like
Retrial.
he got about 68.
68, okay.
Yeah, I kind of stopped counting. 2018 simple battery conviction, 2018 probation, another 2018 probation, 2017 probation. That's all I typed out.
Okay, it's fine. State.
Yes, Your Honor, this incident occurred yesterday, March 22nd, when officers responded to the MARTA station at 30 Alabama Street Southwest. There they learned that an argument between 3 individuals, the defendant, another male, and the victim had escalated when the defendant punched the victim, in this case, Ms. Notrell Rose, in the face. Upon the officers' arrival, they observed red marks to the victim's face. And Your Honor, due to the nature of this crime and the fact that defendant does have a lengthy history that includes violent crimes of battery, aggravated assault, multiple theft by shoplifting, other assaults in the 2004, the state does have concerns of reoffense. And for that reason, the state's recommendation in this case is a $3,500 surety bond, no further contact with Notrell Rose, and a stay away from that location, MARTA, at 30 Alabama Street Southwest.
Okay. PD Wills.
Thank you, Your Honor. Mr. Thomas reports that he was living at the ARC, which is the Atlanta Recovery Center, and that he is a participant in the PAD diversion program through state court, and that he has been a participant for the past year, and that he has resided at the ARC for the past week. And he reports that he would be allowed to return to the ARC if he is able to make bond and if he is released. He states that he recently obtained employment with the restaurant 10 located on North Side, and that he attended orientation but has not begun officially working. He does have a high school diploma, and he is from Atlanta, or from Georgia, or he has been living here since 1996 and has family and friends who reside here. He states that he is unable to afford bond as he was not working or had not begun his employment prior to his arrest. And so we are asking for a $2,500 bond at this time, Your Honor.
Okay. All right, I'm going to order a $3,500 surety bond and a stay away from MARTA at 30 Alabama Street, that station. But I guess part of my question is there need to be a stay away from the address of the victim, which I know is not the MARTA address. That's the incident location. But I don't know what the knowledge is of.
Yes, Your Honor, I don't believe the victim and the defendant had a relationship. So
Okay.
we're just asking for no further contact and a stay away in accordance with that.
Okay. All right. Thank you. All right. So no further contact with the victim, Notrell Rose. No drugs, alcohol, or weapons while on bond. And I think that should be it. Anything else, counsel? Nope. All right. Thank you.
This is the add-on for the SAP.
Uh-huh.
You gotta do it all over again. Oh, you gotta do it over. Oh, never mind, Your Honor.
Okay.
I was gonna try to squeeze them in, but you gotta.
Yeah. Okay.
All right. Let's go to the position 2 on the add-on.
Okay.
Osborne.
Okay. This is 23 CR 001781G, Lionel Osborne, charged with 1 count of battery. The offense date is March 22nd, 2023. Pretrial.
2020 simple battery DV. That was dismissed out of Polk County. He got history out of New Jersey. Last arrest in Jersey. Looks like 2010. Criminal mischief, disorderly conduct. The criminal mischief was a conviction. The disorderly was dismissed. 2008 ag assault on law enforcement harassment. I guess the harassment was dismissed. I guess the ag was reduced to simple assault. That was a guilty. And before that was an 04 arrest. That's all I got.
And how many cycles did you have?
2 out of Georgia and 4 out of New Jersey.
Okay. All right. State.
Yes, Your Honor. This incident happened March 22nd, 2023 at 275 Prior Street, which is the Gateway Center. They spoke with Mr. Joseph Hutchinson, Joseph, common spelling, Hutchinson, Hutchinson, who stated that the defendant accused him of taking his food, then proceeded to hit him multiple times in the face. Mr. Hutchinson did sustain injuries to his left eye and nose, and actually had to be transported by Grady Hospital. They did speak with the defendant, and the defendant stated he asked Mr. Hutchinson twice if he took his food. He stated the first time he said no, and the second time he said yes and offered to give up his food. And at that point, the defendant said he didn't want the food and began to hit Mr. Hutchinson repeatedly in the face. So the defendant in this case, which is the facts presented by the state, that he actually did acknowledge striking Mr. Hutchinson in the face multiple times. As pretrial has stated, the defendant has some history that indicates that this is not the first time he's had a violent incident with somebody else, particularly in the case that was reduced to I believe it was the aggravated case that was reduced out of New Jersey. And I think it ended up being reduced to criminal mischief, and he was given 2 years. Also, we are concerned about the past history, the 2020 simple battery family violence that was dismissed out of Polk County. So for those reasons, the state's recommendation is a $3,000 surety bond, no further contact with Joseph Hutchinson. We're also asking that the defendant stay away from the Gateway Center located at 275 Prior Street and have no alcohol, drugs, or weapons. Thank you.
All right. PD Kim.
Yes, Your Honor. Mr. Osborne is 45 years old, and he was born in New Jersey, and yet he moved to Georgia about 2009. He says he has been here in Georgia more than 14 years, Your Honor. And he is currently unemployed ever since 2020. So he has no financial resources. At this point, indeed, he is residentially challenged. So I was filling out the form for social worker services to have a visit with him to provide housing resources and also behavioral health evaluation to make sure that he does not need competency calendar. We would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, we ask for maximum $1,000 good bond. Thank you.
Okay. I'm going to order the $3,000 surety bond. I'm going to order stay away from the Gateway Center at 275 Prior Street. No further contact with Joseph Hutchinson. No drugs, alcohol, or weapons while on bond. And that's all out order at this point.
Thanks, Your Honor.
That should be it.
Yes.
Mm-hmm. Have they, no, they're not frozen. Who do
No,
we have next, Deputy?
Mr.
Okay.
Osborne, Judge already ruled, so please stay silent. You have a right to remain silent. You don't want to hurt your case.
Am I getting up?
No, please do not say anything. I'll call you, explain everything. Thank you.
We can go to the interpreter case. Position 3, Mr. Herrera.
El señor Herrera.
All right, Madam Interpreter, I'll swear you in. Do you solemnly swear or affirm that you will faithfully interpret from Spanish to English and English to Spanish the proceedings before this court in an accurate manner to the best of your skill and knowledge with no embellishments?
I do, Your Honor, and I please remind everybody to please pause so I can interpret for Mr. Herrera. Thank you.
All right, thank you. All right, this is case number 23 CR 001768J.
Este es el caso 23 CR 001768J.
And Mr. Alvarez Herrera Alvarez.
El señor Álvarez Herrera.
Oh, Alvarez Herrera. You're
Álvarez
charged with
Herrera.
1 count of criminal trespass, damage to property, and a 2nd count of criminal trespass.
Se le acusa por un cargo de allanamiento de morada y por daños a la propiedad. Y también el segundo cargo es entrada y sin permiso o entrada ilegal a un sitio.
The offense date is March 16, 2023.
Este incidente ocurrió el 16 de marzo del 2023.
Pre-trial.
Conferencia previa al juicio.
He may have stepped away. Pre-trial. There he is.
Yeah, second arrest, 2022, driving without a valid license conviction.
El segundo arresto fue en el 2022, manejar sin licencia.
All right, state.
La fiscalía.
Yes, Your Honor. In this instance, the victim is Janet Paredes.
Ok, en este caso la víctima es Janet Paredes.
This incident occurred at her home located at 3144 Forest Hills Drive.
Esta ocurrió en la casa de la víctima en 3144 Horace Drive.
The defendant is Miss Janet's ex-boyfriend, and he came to her house and gained entry without her permission.
El acusado es el exnovio de la señorita Paredes y entró a la casa de ella sin permiso de ella.
She was in the living room when he began trying to gain entry into our home.
Ella estaba en la sala cuando estaba tratando de entrar a la casa de ella.
He started pushing on her door so hard to the point that her door frame broke.
Él estuvo empujando la puerta hasta el punto de que se rompió parte de la puerta.
She said that she attempted to leave the location once he had damaged the door.
Ella dice que ella intentó huir del sitio una vez que se había dañado la puerta.
However, he grabbed her arm when she was trying to leave quickly, causing her to fall.
Sin embargo, él la agarró por el brazo cuando ella estaba tratando de irse rápidamente y lo que hizo que ella se cayera.
She indicated to the state that he has no reason to be at her home and she did not give him permission to be there.
Ella le indicó a la fiscalía que él no tiene nada que hacer en la casa de ella, no tenía por qué estar ahí, tampoco ella le dio permiso para que estuviera ahí.
Our office was able to speak with her today, and she did indicate that she agrees with the facts as stated in the warrants.
Nuestra oficina pudo hablar con ella y dice que ella está de acuerdo con los hechos que se denunciaron en la orden de arresto.
She indicated that they were together for 2 years and share no children and do not live together.
Ella indicó que habían estado juntos por 2 años, pero que no tienen hijos y que ya no viven juntos.
She told our victim advocate that there is a history of verbal abuse between them and that she is afraid of the defendant.
Ella le indicó a la persona encargada de las víctimas que se ha habido abuso verbal entre ellos y que ella le tiene miedo al acusado.
She indicated that she attempted to file a TPO in January, however, it was not granted because the defendant could not be found.
Y ella dijo que había tratado de buscar que dieran una orden de restricción en enero, pero no lo pudo hacer porque no se encontraba el acusado.
Last statements are outside the parameters of this actual case. What she told victim witness is irrelevant at this point. It's hearsay, and a TPO that may or may not have been filed or granted is also outside the purview of this case.
It
Esto
goes
que-
to our difficulties.
Que esto que acabamos de hablar de la restricción y de lo que ella trataba de hacer y lo que le dijo a la persona que aboca por las víctimas, que eso es testimonio de oída y que está fuera del perímetro de este caso ahora.
And
All
the
right, so noted, Mr. White. Miss Paredes is here, and we can cross-examine her, question her about other incidents or things relevant or not relevant to the case.
Que el señorita Paredes se encuentra aquí, le podemos hacer el interrogatorio acerca de lo que es pertinente o no pertinente al caso, como un interrogatorio que se le haga a ella.
All right, go ahead, Ms. Duncan.
as I was stating, she indicated that she has been granted a TPO for the next 30 days.
Y como dije anteriormente, le acaban de otorgar una orden de protección por los próximos 30 días.
Your Honor, given the nature of the incidents as alleged, given that this defendant had no reason to be there,
Debido a lo que se alega en el incidente y debido al caso de que este acusado no tenía por qué estar ahí,
we do have concern about the particular safety to this individual victim.
tenemos preocupación por, en particular, de la seguridad de esta víctima en particular.
And the fact that he was so adamant to damage her door further increases our concern about her safety.
Y el hecho de que él estaba tan insistente en romper la puerta también nos da preocupación en que tenemos en relación a la seguridad de la víctima.
This case is currently set at a $5,000 surety bond for count 1.
En este caso se ha puesto una fianza de $5,000 de fianza en el cargo número 1.
The state is amenable to reducing that surety bond to a $4,000 total surety bond for both counts.
Y la fiscalía está dispuesta a reducir esta fianza, de esta caución a de $4,000 por los dos cargos.
The breakdown being $2,000 per count with no further contact with the victim in this case.
La forma como lo vamos a hacer los detalles son $2,000 de fianza por cada cargo y no tener ningún tipo de contacto con la víctima en este caso.
A stay away from the victim's residence.
Mantenerse alejado de la casa de la vivienda de la víctima.
1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
No tener ningún tipo de drogas ni alcohol, ni tampoco armas bajo la ley de Georgia, y también tener un curso de reconocimiento de esto.
And the victim is on the line, so the state would like the court to sound for her when appropriate.
Y la víctima se encuentra aquí en la llamada y la fiscalía desearía hablar, o sea, llamarla a ella cuando sea necesario.
All right, Miss Janet Paredes, do you want to address the court?
Señorita Janet Paredes, ¿usted quiere dirigirse a la juez o a la corte, al tribunal?
Judge, if I may, we're not requesting any kind of hearing at this point or challenging the no further contact or stay away order, so I'm not sure that it's even necessary.
Okay,
And
all right.
and
If
as,
you're not challenging the stay away,
Your Honor, if I
Why do-
may, just for the record, in accordance with Marcy's law, this victim is allowed to speak.
Que la víctima tiene derecho a hablar, aunque no se está disputando que se mantenga alejado de la víctima, pero hay una ley que exige que que dice que las víctimas pueden hablar.
I'll allow some limited statement, Mr. White, under Marcy's law, but I do understand with you not challenging. And Miss Paredes, is it Paredes? Don't want to mispronounce your name. If you want to address the court briefly, I will allow that because you are here. And if you
Señorita-
do, I'll need to swear you in. So do you want to address the court or not?
Señorita Paredes, primero que nada, necesita intérprete. Desea hablar, decirle algunas palabras a la juez. Primero que nada, tiene que levantar la mano para que la juramenten y bajo una ley tiene derecho a decir algunas cosas. ¿Necesita intérprete?
Sí.
Ok. ¿Usted quiere dirigirse a la juez? ¿Quiere decir algo?
She does want to address the court.
I am trying, first of all, I asked her if she needed an interpreter, so she said yes. And now I'm trying to find out if she wants to address the court.
Oh,
May I
okay.
ask her again? I just wanted to make sure that she
Yes.
needed an interpreter. Señorita Paredes, ¿usted quiere dirigirse a la juez? ¿Quiere decirle algo?
Solo quiero
No, no,
saber.
primero que nada diga si quiere dirigirse a la juez para que ella la juramente si lo va a hacer. ¿Quiere dirigirse a la juez? Yes, I
Sí.
do want to say something.
All right, raise your right hand.
Levante su mano derecha.
Do you affirm that the testimony that you're about to give
¿Usted jura que el testimonio que usted afirma que el testimonio que usted va a dar ahora
is the truth and nothing but the truth
es la verdad nada más que la verdad?
under the penalty of perjury?
So pena de perjurio.
Sí, lo juro.
Yes, I do. I swear.
Put your hand down.
Puede bajar la mano.
First, I want to ask, are you in fear of Mr. Herrera?
Primero que nada quiero preguntarle, ¿usted le tiene miedo al señor Herrera? ¿Teme del señor Herrera?
Sí.
Yes.
And I understand that you do not want any further contact. Is that correct?
Yo entiendo y tengo por entendido que usted no quiere más contacto con él. ¿Es eso correcto?
Sí.
Yes.
All right. Is there anything else briefly that you need to tell me?
¿Hay algo más que usted me quiera decir, que necesite decirme brevemente?
Solo tengo una pregunta. Si a él entregaron que tiene una orden de restricción y que vamos a tener otra corte.
I just have a question. Did he receive the fact that, or know the fact that there is a TPO and that we're going to have a court about that? Does he know that?
I don't know if he knows it, but I know it because the prosecution has told me, but that's not something I'm going to address. That's a different court, different judge. I just didn't know if there was anything else you wanted to tell me in regard to her fear or no contact with the victim.
Yo sé, yo no sé si él lo sabe, yo lo sé porque me lo acaba de dar la fiscal y además de eso se habla en otra corte. Solo quiero si me quiere decir algo acerca de su miedo o de que tiene contra el señor o algo de que tenga miedo con él.
No era todo lo que le quería decir.
No, that was all I wanted to say.
All right, thank you.
Okay,
Any
gracias.
cross-examination, Ms. Duncan?
Nothing further from the state.
Any cross-examination, Mr. White?
Judge.
All right.
No hay
All
más
right.
preguntas.
Thank you, Ms. Paredes.
Gracias, señorita Paredes.
All right, Mr. White?
Yes, Your Honor. Mr. Herrera Alvarez is 28 years old. This is his first lifetime non-traffic arrest.
Su señoría, el señor Herrera tiene 28 años. Esta es la primera vez que tiene un arresto que no tenga nada que ver con situaciones de tránsito.
He has his own business, and in fact, he will not qualify for the service of the public defender after today.
Él es dueño de su propio negocio, por lo tanto no va a poder calificar para que se le asigne un abogado defensor público después de hoy.
As I said before, first arrest of any other than one traffic offense. No indication of any violence. He weighs 110 pounds. I'm not sure how he broke a door frame.
Okay, este es el primer arresto que él tiene y no tiene nada que ver con ningún tipo de arrestos con violencia. Él es una persona que pesa 110 libras. No sé cómo pudo haber roto la parte de la puerta que rompió.
He's denying the facts as alleged at this point, and we're asking him to be allowed to sign his own bond, considering his lack of history. He's been in the area in Atlanta for 7 years, and as I said, as a business owner, so he has significant ties to the community.
Él está disputando los hechos como se dicen. Como le digo, él tiene su propio negocio, ha estado aquí en la zona de Atlanta por 7 años, tiene su propio negocio, tiene vínculos relacionados con la comunidad.
All right. I will order the
Oh, Judge, and I'm sorry, briefly. So my paperwork only has the one criminal trespass damage to property. It seems like a second charge of criminal trespass for one incident is not warranted here. We would ask that be dismissed, that the criminal damage to property is what he's charged with.
Okay.
And
También aquí en mis documentos solamente tengo que hay con un solo cargo, que es el allanamiento de morada con daño a la propiedad. No había otro cargo de entrada sin permiso. Estoy pidiendo que se elimine este cargo y estoy pidiendo que se le otorgue una fianza bajo palabra.
This case has been accused and a motion to dismiss would need to be filed before Your Honor. However, the state is allowed to add such charges given that in this instance, he broke a door and was not supposed to be there. That is the case of the criminal trespass.
Se puede hacer este impedimento para que se pueda retirar este cargo, pero en este caso, como él entró sin permiso y como también dañó la puerta, por eso la fiscalía puede añadir este cargo debido a las circunstancias del caso.
All right, I will not entertain the dismissal at this point, Mr. White.
En este
But
momento no
I'm,
voy a tomar en cuenta que se retire el caso, señor White.
but I'm going to order the $4,000 signature bond. And I
Pero,
will order that through pretrial.
pero se va a ordenar que se le otorgue la fianza bajo palabra de $4,000 y que lo haga por medio de conferencia previa al juicio.
Which will be $2,000 for each charge.
Que va a ser $2,000 por cada cargo.
And with that signature bond, I'm going to order no drugs, alcohol, or weapons while on bond.
Y mientras hago esta fianza bajo palabra, no puedo utilizar ni drogas ni alcohol, ni tampoco tener armas de fuego mientras esté bajo esta fianza.
I'm going to order a stay away from 3141 Forest Hills Drive.
Y tiene que mantenerse alejado de 3144 de Forest Hill Drive.
I'm going to order no further contact with Janet Paredes.
No puede tener más contacto de aquí en adelante con Janet Paredes.
And the defendant should stay 200 yards away from her.
Y el acusado tiene que mantenerse 200 yardas alejada de ella, de distancia entre ellos.
And have no contact with her by phone, mail, email, or social media, etc.
Tampoco puede tener ningún tipo de contacto por teléfono, por correo electrónico, por redes sociales, por mensajes, ningún tipo de contacto de ninguna forma y manera.
Nor any contact via third parties.
Y tampoco puede utilizar a terceras personas para contactarse con ella.
And I'm going to order I was going to order the one-day anger management through pretrial since they give that course.
Iba a ordenar que hiciera un día de control de un curso de control de temperamento.
Anything else, counsel?
Algo más, abogado.
Nothing further.
No más, no tengo más nada que añadir.
So
thank you.
Are you ordering it or not?
Yes, the one-day anger management course, yes.
Anger management or anger awareness?
I mean, anger awareness, I'm sorry. Anger awareness.
Tiene que tomar un curso de reconocer, cuando se enoja, y va a ser un día para que te haga ese curso, un curso de un día.
If I could inquire with pretrial, do they have Spanish speakers that he would be able to report and speak with about all of this?
Yeah, they'll order an interpreter. Can you let him know, Madam Interpreter, that he will receive a sheet of paper letting him know when orientation is with pretrial service?
Ok, le van a mandar un documento, un papel cuando le toca ir a hacer la orientación de la conferencia previa al juicio, que es lo que tiene que hacer para que le indiquen todo lo que va a hacer, señores. Le van a mandar eso para que usted sepa, para que vaya sepa cuándo es la orientación, para hacer todo esto que le están mandando a hacer.
Tom, I'll send him an email, let him know to order one for his orientation.
Le van a mandar por correo electrónico para cuándo es la orientación.
All right. There's nothing else that'll conclude this case.
Okay.
Thank you, Your Honor.
Your Honor, may I be excused?
Yes, you may. Thank you so much.
You're very welcome. Thank you.
All right. Thank you.
Yeah.
Ms. Paredes may be excused as well. All right. Thank you.
Position 1 on the add-on, Mr. Hadley.
This is 23 CR 001782F, Corey Hadley, charged with 1 count of willful obstruction of a law enforcement officer, Penn State, March 22nd, 2013, pretrial.
Is this the plea dude?
It is.
Yes, I have 2 pleas.
Solo plea, right?
Yes.
You still want the history or you want to play?
I'm sorry.
You want me to get a history or you about to do the plea?
No, I will do the plea.
All right.
All right, Mr. Hadley.
Yes.
I understand that you would like to take a plea in this case. One count of willful obstruction of a law enforcement officer. You wish to plead guilty?
No.
I'm sorry?
Do you wish to plead guilty? You're doing a plea. Yes.
Okay, I can't hear you too well. Speak up a little bit for me.
Yes.
Okay, and so in pleading guilty, I need to ask you a series of questions to make sure that you understand what you're doing and that you are willfully pleading guilty, okay?
Yes. Yes.
All right, state what is the offer?
Your Honor, there is time served.
Can't hear you,
This
Deputy
defendant
Falk.
has,
It looks like it was going out a little bit. Now you're back, I think.
is that a little bit better?
Yes.
Okay, the
Okay.
state's offer is time served. This defendant has a fugitive from justice warrant out of Alabama. That is the reason why he was arrested. He didn't offer violence to the officers. He just tried to run when they went to arrest him on the outstanding warrant. So that's why the state is offering time served to let him go and handle his business in Alabama. And that is all for the state.
All right, thank you. All right,
How long has he been in custody? I apologize. I need to put my paperwork.
looks like 2 or 3 days. How long is it, Deputy Falk?
He was arrested at 7:15 p.m. yesterday, so this will be 1 day.
Okay, thank you.
All right, and Mr. Hadley, you wish to represent yourself, is that correct?
Yes.
Okay, and let me ask you this, are you presently under the influence of any medication, drugs, or alcohol?
Ma'am.
Did you say no, ma'am?
No.
Are you asking me a question? Did you hear what I stated?
No.
Okay, are you presently under the influence of any medication, drugs, or alcohol?
Yes, I received to take Depakote and
Oh, you just have some prescribed medication?
yes.
Okay, that's fine. Or do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
You understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you're prepared and agree to waive these rights today?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
Didn't hear.
Huh?
No.
Okay. Has anyone promised you anything to plead guilty?
No.
You understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Do you understand? Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the one charge against you?
Yes.
All right, and so it is your intent with the willful obstruction of law enforcement officer, and how do you plead?
Yes.
All right, so this is a time served plea. I will accept your plea and you will be released on the other warrant shortly.
Okay.
Okay,
Thank you.
all right, you're welcome.
This is the other plea, Mr. Horton.
Okay. Oh, right, that's from my earlier calendar, okay.
Yes, ma'am.
This is case number 23 CR 001427 G, Michael Horton. You're charged with 1 count of driving, of fleeing, or attempting to elude a police officer, and a 2nd count of knowingly driving a motor vehicle on a suspended, canceled, or revoked registration. Both offenses occurred on February the 17th, 2023. This is a plea, so state, let me know what the terms are.
Sorry, I keep going on to mute. So the recommendation on this case, Your Honor, was 12 months probation. We were also asking for a $250 fine on count 1, as well as 32 days in jail. He would get credit for time served for 16 days. Count 2, we are requesting a $500 fine. And I believe, let me just check. And I believe those are the only terms and conditions of the probation. We are, and I actually inadvertently switched those around. Count 1, it's the $500 fine. Count 2, it's a $250 fine, and the balance is on probation. The state is asking the defense to stipulate to identity as well as venue and the factual basis. Thank you.
Okay. All right, Ms. McLeod.
Yes, Your Honor, we do stipulate to all of those items.
All right.
I have one question. Is probation available for him to talk with? Because he's going on probation.
Oh, yeah, they do need to be.
Mm-hmm.
They were on my earlier calendar, but they're normally not on C.
Is there someone who can
I
reach
have
out to them?
contact information for Mr. Horton, which I can get to probation. I have a phone number, a physical address, as well as an email address for him.
Yes,
I know
Mr.
that-
McLeod, as long as you have the contact sheet information, you can forward that information to JCS probation and they'll email or call him to set up his appointment to come.
Yes, I have a phone number and an email address and a street address.
Okay, great. All right, we will make sure he gets that information to report. And also obviously explain to him how important that it is that he does contact them immediately. And so, Mr. Horton, I understand you want to plead guilty, correct?
Yes, ma'am.
All right. And I'm going to ask you the same series of questions so that we make sure that you understand what you're doing and that your plea is free and voluntary, okay?
Yes, ma'am.
All right. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
All right. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're also giving up and waiving the right to have a trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of this guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
So as to the charge of driving, fleeing, or attempting to elude a police officer, how do you plead?
Guilty.
And as to the charge of knowingly driving a motor vehicle on suspended, canceled, or revoked registration, how do you plead?
Guilty.
All right, and you understand that you will be on probation. You pay those fines, a $500 fine for the first charge and $250 fine for the second charge. You understand that?
Yes, ma'am.
Okay, and your attorney will give you the information as to how to contact probation so you can get signed up.
Okay. I'm sorry.
Go ahead.
Yes, I was going to say this was not part of our discussion, but my client expects a baby very soon, and he also has an 8-year-old. So I was wondering if the state would agree that once the fines are paid, that he could, that his probation could be concluded.
We'll
State.
agree to that after 6 months.
After 6 months, okay. If he's paid his fines in full
All
after.
right.
6 months,
All
okay.
right.
And I will say, we will not agree to terminate, suspend. So we will suspend the remainder of his probation after 6 months if all the fines and fees are paid.
All right.
Thank you.
All right. That will be the order of the court as well. You have that, Ms. Bridgewater?
Yes, ma'am.
Okay. All right. Thank you. If there's nothing else, that'll conclude this case. Good luck to you, Mr. Horton.
Thank you all.
All right.
And Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may. I'm glad we could do that.
So am I, Your Honor. Thank you.
All right. Thank you.
Next, we have position number 1, Mr. Beverly, position number 1.
Okay. This is 23 CR 001765C, Kenyatta Beverly, charged with 1 count of battery family violence. The offense date is March 22nd, 2023. Pre-trial.
Yes, ma'am.
Fourth arrest.
Okay.
2020 simple battery conviction. He got an open battery in state court, 22 CR 005 584C. He was put on probation on the 1st of this month for disorderly conduct. That's 20 CR 004 596C. That's it.
All right. State.
Yes, Your Honor. In addition, I saw in the criminal history that this defendant had a 2020 battery family violence arrest and a 2018 aggravated assault arrest that was dismissed. In that 22 CR 005584C case, it's battery, and it is the same victim in this case, Your Honor. And in that instance, he pointed a firearm at this victim. For today's instance, it did occur at 5007 Upper Elm Street in South Fulton. It's indicated to officers that they responded to that location, and when they arrived, they made contact with both the defendant and the victim, in this case, Ms. Kiara Hanks, Keyara Hanks, common spelling with an S. It's indicated that Ms. Hanks said that, well, they live together and they share a minor child. She indicated to officers that they were sleeping, and she was awakened to the defendant sleep talking, and she told him to be quiet. She got up to check the heat and to check on the minor child. She stated that when she was getting back into bed, the defendant woke up and began choking her with 2 hands around her neck. She stated that she was in fear of being choked to death because she had asthma and the cover was over her face, so she was having difficulty breathing. She stated to officers that she did have to fight, but it was only in self-defense, given that the defendant was on top of her and she was trying to get him off. Officers did talk with the defendant in this case, and he gave a different recitation of the facts. Your Honor, I just want to make it clear that this was a co-defendant arrest. However, the reason for the co-defendant arrest was because that both of the parties had injuries. It did not indicate in any of the documentation that the co-arrest was because of equal parts aggression. So the state has determined that in this instance, given the facts and this defendant's background and history with this particular victim, that he is likely the primary aggressor. For those reasons, we do have some concern about the risk of reoffending, given this defendant's history of a violent nature and the particular history with this individual victim, given that he does have a previous arrest for battery, family violence, and aggravated assault, as well as an open case against this particular victim. And so we're going to be requesting a $3,000 cash only bond, no further contact with the victim in this case, a stay away from the incident location, third-party child contact, 1-day anger awareness, and no further violations of Georgia law. Your Honor, we just have extreme concerns. And of course, we were not able to speak to the victim as she was initially arrested, given that she had given the defendant some marks, and according to her, it was in self-defense. So we'd ask for that $3,000 cash bond and the conditions as previously stated on the record.
All right. What, tell me the victim's name again.
Her name is Kiara Hanks, Keyara, Hanks, Hanks. She is the mother of the same child as the defendant and the other person who lives in the household.
All right. Mr. White?
Judge, in the very same police report, Mr. Beverly states that he is the one who was attacked by Ms. Hanks, and he was the one defending himself. The state has dismissed Ms. Hanks' charge just because, without speaking with her, without speaking to Mr. Beverly, and just decided that, oh, it must be him. So while the officers also did not state that he was the primary aggressor within the police report, they didn't know. That's why she was also arrested. I think it's a very viable defense that he has, that he was the one attacked. Additionally, the residence where this occurred is actually Mr. Beverly's mother's home, and she lives there as well. So we're asking that there not be a stay away from the address, simply because it is Mr. Beverly's mother's home, and he would be the one that would be living there. I understand while there may be some transition, there has to be a stay away while she maybe finds someplace else to stay. But there shouldn't be a stay away from the address, because once she's out of there, he should be allowed to go back to his mother's home. We're asking that the bond be a $2,500 good bond at this point, not a cash bond. He is not employed at this point and does not have any income. He does help take care of his mother and the child that the two share together. So we're asking it to be a $2,500 good bond and to not have a stay away from the address.
And Your Honor, just to be clear, we've identified this defendant as the primary aggressor based on his history, including his previous history with this particular victim, where he pointed a gun at her in a of 17-4-20.1. And given the fact that she indicated that he choked her in this instance to the point where she thought she was going to die. Yes, the defendant did receive markings. However, the paperwork indicates that those markings were scratches in accordance with what happened. So it's in the state's purview to make that determination. And for these reasons, we're still going to ask for that $3,000 cash. It's a continuing pattern of violence between these parties involving firearms and choking. So we have some serious concerns, especially since we were not able to speak to
And at this point, there are no convictions that I'm aware of. So the state just made the decision based on arrest without any convictions. So there is no, at this point, it's just the state's opinion, which very well could be mistaken.
based on the facts provided by officers. Nothing further from the state.
All right. And what did you say again, Mr. White, about the work history for Mr. Beverly?
He is currently not employed, so he does help take care of his mother and his child.
I am concerned about the open battery case, the 22 CR case. Is that the same victim?
Yes, Your Honor.
And then
Again,
we
Your Honor,
have-
that is not a conviction at this point. It's merely an accusation. And I understand the court's concern, but you need to put it in perspective as well.
All right.
He's pointing a gun at her.
I'm going to order a $2,000 cash bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order a no further contact with the victim. And if there's to be visitation allowed with the child, that it must be facilitated by a third party. And right now, until we can find out, since this just happened, I'm going to order a stay away from the incident location. I believe it was on Upper Elm Street?
Yes.
Correct.
Mm-hmm. I'm gonna order that stay away from now. If we need to address it with a bond modification, we can do that. But I want to make sure that the victim and the child are safe wherever they are at the present, till we know that they are not
Judge,
going to be with the defendant. Yes.
Judge, I would argue that the stay away is sufficient to do that from the no further contact with her. The address, staying away from the address is just superfluous at this point because he still has the no further contact order against her. If he does go there and she's there, then he's in violation.
Right, but it's
So-
indicated she lives there, but just to cover all bases, the stay away and then no further contact is appropriate. Whether she be at home where she's alleged to have lived or out, it'll make sure she's safe.
Contact is contact, and he cannot have contact with her, is my point, period. There
Right.
at the address or anywhere else in the state. So the stay away from the address, which is his mother's home that he resides in, while there's some sort of transition period, he still has to stay away from her. But if she were to move out, he should be allowed to go back.
Right. And I understand your point to it. I just don't know when that will be, when she will be able to move out, her and the child. Yes, he's supposed to not have any contact with her, but some people take that to mean, well, but I can live there and just avoid her, which would be probably impossible. So I want to make sure that she's given ample time to move if that's what she's doing. The fact that they already live there together, just don't know what the status is. And I'd rather do that with a bond modification hearing rather than doing that now in case he makes bond and gets out and then says, well, they didn't say I couldn't live here. So I don't want to put the victim in any additional fear or any other situations until we know for sure that she has found another place to live and is not residing at that location. If he can, show us proof of that, or we have some assurity of that once the state has maybe been able to contact the victim, and then they can provide that information as well. All right. Thank you. Mhm.
Position 4, Megan.
This is the case that we had started, I believe. 23 CR 001769G, Secondie Landry. You charge of 1 count of theft by takings, 2 counts of theft by taking. Offense date March 22nd, 2023. And I wrote down that pre-trial, it said he had 13 cycles.
The 18.
Oh, 18.
I'll start off.
Yes, go ahead.
18 appears to have an open case in state court. Theft of lost mislaid property, reckless conduct, misdemeanor possession of marijuana. It's 19 CR 007 624G. Open possession of a Schedule II controlled substance. Possession of drug-related objects. It's 23 CP 216459. Appears to have open robbery out of Clayton County and an open battery as well. 2021 trespass conviction. 2020 fade to appear. 2020 he had a battery charge of a touchy-feely nature. 2019 fade to appear. 2018 shoplifting. 2017 theft by taking. 2016 fade to appear. And I think the 2018 shoplifting was a conviction, if I'm not mistaken. Screen down.
All right.
That's it.
All right, state.
Yes, Your Honor, that 2018 theft by shoplifting was a conviction. This defendant also has a 2017 theft by shoplifting that was dismissed and a 2019 felony theft by shoplifting that was also dismissed. Given that the state does have concerns about this defendant's particular risk of reoffense given his criminal history. In this instance, it occurred on March 22nd, 2023. Officer Irving was patrolling the area near the Home Depot, which is located at 2525 Piedmont Road. He saw someone running at a high rate of speed wearing a winter coat. As he indicated, he said that he saw another person running behind that individual and shouting, "He stole my bag, he stole my bag." The officer was able to make contact, and that person who stated that his bag was stolen was one of the victims in this case, a Mr. Benjamin Lewis. That's Benjamin Lewis, common spelling. It's indicated from what he told officers that he is an employee of that Home Depot, and he placed his backpack in a cart while he was going to the restroom. He had previously seen the defendant in the store and thought nothing of it other than he was looking at him in some weird way. He came back out, his bag was gone, and he indicated to officers that at that time, the defendant actually approached him and started to ask him questions. So Mr. Lewis asked him if he had his bag. He indicated that no, he did not have his bag under the winter coat. However, when the Mr. Lewis indicated that he did in fact have his bag, the defendant took flight from Mr. Lewis and officers. There was a foot chase where the defendant was eventually taken down, and officers were able to retrieve Mr. Lewis's gray backpack, as well as 2 cans of lighter fluid that were from the Home Depot. So it's for these reasons, Your Honor, given this defendant's history, we do have concern about the risk of reoffense as stated before, because this is his at least 5th theft-related either conviction or arrest. We're concerned about the flight risks, given that he has probation revocations in his history, and we're concerned about his likelihood to respond positively to the legal process. This defendant does have an open case of a theft nature with the state court. So we're going to be requesting a $3,000 total surety. That's $1,500 per count. No further contact with Benjamin Lewis. A stay away from the Home Depot located at 2525 Piedmont Road. No alcohol, drugs, and weapons, no further violations of Georgia law, and an anti-theft class. And we don't know, we were not able to make contact with Mr. Lewis. However, we would like the court to sound for him when the time is appropriate, just in case he's here.
All right. Mr. Benjamin Lewis. See on the Zoom, Benjamin Lewis. No, Mr. White.
Yes, Your Honor. Mr. Landry's 24 years old. He is employed with State Farm Arena. He is the father of a 2-year-old son that is in his custody. His son is currently residing with his mother while he's in jail. We're asking that he be allowed to sign his own bond so that he can get back to care for his son. His mother also works and cannot keep him. So there's a possibility that she's going to miss work in order to take care of the child, or defects may get involved. So we would like Mr. Landry to be released on a signature bond so that he can care for his son and his mother can go to work. Additionally, Mr. Landry's recitation of the events were a little different than the state's. He said he found the bag and then went to ask if there was a lost and found or something to that effect at the Home Depot. He was told no. He was leaving with the bag when Mr. Lewis chased him out. He was concerned that he thought Mr. Lewis had a gun, was scared, and continued running. Again, where the two lighter fluids, the property of Benjamin Lewis and the Home Depot. So are they saying that he took the bag and then went and put lighter fluid in it in the store and then ran out? Is that what the state's?
The state's position is that in accordance with the documentation, officers were able to recover the gray bag belonging to Mr. Lewis, and the 2 cans of lighter fluid that belong to the Home Depot.
Okay. I guess, all right. That's all I have, Judge. We just asked that he be allowed to sign his own bond. He does also have a disability. He was born with amniotic band syndrome and therefore born without one of his hands. Yet he is still employed and contributing to society. So we'd ask that he be allowed to sign his own bond. Given the total cost of the items here can't be more than $40 or $50, $3,000 seems a little excessive.
And based on his history, Your Honor, we just renew our request, nothing further.
All right, I will order a $2,000 surety bond, and that's $1,000 on each case. I'm going to order no drugs, alcohol, or weapons while on bond. Going to order stay away from the Home Depot at 2525 Piedmont Road. I'm going to order no further contact with Benjamin Lewis. And I think that'll be it for now. Anything else, counsel?
Nothing further from the state. Thank you, Judge.
Nothing
All
further.
right. Thanks. Anyone else? Let's see, or is that? Let's see, do we have any more?
We have
Yes, I do.
Oh, we have a number 5, McMillan
Several others.
and Peters. It's like we have 4 maybe left. Williams,
In position 5, 10 for home 2.
okay.
Position 5, what?
Lawrence McMillan,
For
Yes,
room
ma'am.
2.
okay. 23 CR 0017770Y, charged with 1 count of battery. Penn State, March 22nd, 2023, pretrial.
Yeah, 23 cycles. Last arrest was in February for battery, DV, second subsequent. Excuse me, false imprisonment, cruelty, and the third reckless conduct. I think those were dismissed. He has an open shoplifting in Fulton County. He got an arrest in 2014 out of Texas. Assault causing bodily injury, family member. That was a conviction. Back to the Georgia history. Let's see. Yeah, the February 2022, I just called out. 2021 battery out of Hateville, 2020. Terroristic threats, criminal trespass out of Union City. 2019 battery conviction. That was out of state court, 19 CR 003 258D. 2018 probation, 2016 ag assault. Got a battery DV, second subsequent conviction. That was from a 2016 or 2015. Got a theft by deception conviction, 2015, shoplifting arrest, 2015. 2015 simple battery, FTA. Let me know you heard enough.
Yeah.
Hmm?
I have.
Okay.
Thank you. State.
Yes, Your Honor, this incident occurred on March 12th at 3331 Sims Street, apartment 4 in Hateville. The victim in this case is Judy White. It's indicated to officers that the victim was hanging out at the defendant's apartment, and there was a verbal dispute that ensued over money that was owed either to Miss White or to the defendant, and she was asked to leave, and when she got up to leave, she stated that a physical altercation ensued where the defendant, when she tried to leave, because he said he wasn't giving her money back, my apologies, she got up to leave and he proceeded to punch her in the face twice, and leave lacerations and bleeding near her eye sockets. It's indicated that in addition to that, there was a witness by the last name Lowe, who is the property manager, who stated that they had been drinking all day and that he in fact witnessed the defendant hang the victim, Miss White, over the second floor railing during their altercation. Your Honor, given this defendant's extensive history in terms of violent convictions all the way back to 2009 for battery, family violence, battery, as well as the probation violations and reckless conduct, the state is going to be requesting a $6,000 total surety, no further contact with Judy White, 2 weeks of anger management, no alcohol, drugs, and weapons. I just want to be clear that the state is not requesting a stay away at this time, given that this is not the victim's address. She was just visiting the defendant. However, we will request the $6,000 surety with no further contact and the anger management courses and no alcohol, drugs, and weapons.
All right, Mr. White.
Yes, Your Honor. Mr. McMillan has a vastly different opinion of the incident. First of all, Mr. McMillan was coming home from work. Miss White asked Mr. McMillan to borrow his phone. Some sort of transaction occurred, Venmo or something like that, that's beyond my complete understanding. But apparently then there was some money, additional money that was owed to Mr. McMillan. Miss White said she didn't know him. She ended up letting herself in his apartment uninvited. When he asked her to leave, she refused. He grabbed her by the arm to guide her out of the apartment. She is beyond high and then falls. And that's how she sustained her injuries. She had no right to be in his apartment, and therefore we're asking for, I understand he does have some history. It sounded like a lot of that was dismissed. We're asking for a $2,000 good bond. He is employed with Marco's Pizza. He doesn't make a lot of money there, but he is employed, and he has family here and has been in the area. I believe he said 16 years. His family, mother, father, grandparents are all here, significant ties to the community. I didn't hear any issues with his ability to appear in court. So we're asking for a $2,000 good bond.
And Your Honor, my apologies, I forgot. We were not able to make contact with Ms. White. However, we would like the court to sound for her when appropriate. And just to clarify, this defendant does have 4 violent convictions going back to 2009.
Okay. Judy White, is Judy White on the Zoom? Judy White. Don't think that she is. I'm going to order a $3,000 surety bond. I'm going to order no further contact with the victim, Judy White. Gonna order no drugs, alcohol, or weapons while on bond. And that's all I order at this time.
Thank you, Judge.
Thank you.
Here in courtroom 2, we are finished. Maybe be excused. Can you speak to her real quick?
All right.
So who we got next?
I know, she didn't say that.
Somebody waved or something?
Courtroom 2, we've done with everyone. He wanna come back to the chair so he can ruin his chance of getting out of jail. Come on.
Now, who is that?
Excuse me, ma'am. My name's Secondie Landry. I was just talking to you
I can't hear you. I can't understand what you're saying. Who are you? What's your name?
Landry, Secondie Landry.
Let me see. Hold on a second.
It's Tom White's client.
Oh, Mr. White, are you still here?
It's position number 4. This person.
Yeah, Mr. White, I don't know if you want your client to speak.
I indicated that to him at the time.
Right, yeah, I am not inclined to rehear this at this time.
I just want to say, I have my son, he's with my mom, but my mom has to go to work tomorrow. So the only reason I was asking you if you could please sign the bond for me is so I can take care of him, or else I'd lose him to the defects and everything.
Ms. Landry, I explained all of that to the judge. And
Yeah, and the
his
state
rule.
was asking for 3,000 and I did 2,000.
Yes, ma'am, but I don't have anybody who will be able to come and pay for that for me. That's the only problem. My family, I burned a lot of bridges. You know how they read all that stuff, and they won't pay for me. But I'm doing better, and I promise I'll come to court and everything. I don't be skipping court or nothing. I was just asking, please, if you would please, have mercy on me. That I just wanted to say that.
Yeah, I don't know if the state has anything that you want to add.
The state would object to that given this defendant's history, Your Honor.
Because those past shopliftings, it was just like I think that was like a little beer. It was like one beer. It wasn't nothing. And I was holding it up underneath my arm. And since I have one hand, I was holding it under my arm. The security guard thought I was stealing it, but I wasn't. That's why I got dismissed. You know, even that was my history. It was really small and petty.
Right, but you had 18 cycles, quite a bit of history. So
yes,
I'm going to leave it at the 2,000.
I've been getting in trouble a lot, but I was just asking for this one time. Would you please sign, please, so I could get to my son? I know there's no excuses that could be made, and I still have to answer for this. I just wanted to be able to get to my son because he's my only dependent and he's dependent on me.
Right. I understand you have to make different decisions and better decisions,
and I know
knowing that.
I just don't have anybody who can come and do that.
Okay.
I don't have anybody who will come.
Okay. Well, that's the lowest I can do is the 2,000, which 10% is 200.
Yes, but could you sign it for me?
Your Honor.
No, I can't give you a signature bond, so I've already made my ruling. Okay. All right. Good luck to you. Yes. What you gonna say?
Nothing further.
So did we do number 7?
We did not. Is that somebody that's bonded out?
Yeah.
Peter's bonded out.
He did.
I don't know. I'm asking.
I don't think so. Let me check one moment.
No, Your Honor, I spoke with him this morning.
Did? Oh, maybe they did not bring him.
I'm showing we still have 3 cases left. I know one of them is a waiver.
Which one's a waiver?
Which one? Do you know?
Ray?
Yes,
Ms.
Ray.
Kim.
So what's with
Yes,
number
Your
13?
Honor. I mean, yes.
Deputy in courtroom 2, or I know the deputies have left.
But I'll tell you who they are. I have one for position 13, Erica Williams,
Okay.
Okay.
and one for position 8,
So waiver
Octavius Ray.
for 13.
So I know we have waivers for 2 of the 3. I don't know what's going on with position number 7.
Your Honor, I'm not showing him as bonded out in Odyssey from what I can see.
Right, and they wanted to hold 8 to the end. Deputy, can you all hear me in courtroom 2? Peters, number 7.
He's a medical reset.
Oh, medical reset. Okay.
Yes,
Okay.
ma'am.
And what about position 13?
She waived
It's a
her
waiver.
appearance.
Okay.
And also Ray, I think he's position 10.
Number 8. You're number 8.
8.
Number 8.
Yeah.
Yes.
Okay.
Yes.
Okay.
Waivers for 8 and 13.
Yes,
Gotcha.
ma'am.
All right. Thank you very much.
You're welcome. Have a
All
good
right.
day.
Thank you. Uh-huh. All right. You all want to do 8 next?
Yes.
Oh, no, we're doing 8 at the end. So
Yeah.
let's do
13.
13, right?
All right. 5 cycles.
5, okay.
I'll give you the Georgia history first.
All right.
Last arrest in Georgia was 2010. Possession of a Schedule 2 sale of marijuana. Those were dismissed. Well, one of the sales was a conviction. 2009 probation, 2008 probation, 2008 given false name on 2 counts and a probation. Got 1 cycle out of North Carolina, 2022. Larceny by employee. That's it.
All right. State.
Yes, Your Honor. This incident occurred yesterday, March 22nd, when officers responded to the Imperial Hotel located at 355 Peachtree Street Northeast. There they learned of an argument that occurred in the hallway of the hotel between the victim in this case, Miss Lisa Riley, and the defendant. When the defendant had asked Miss Riley for some money, Miss Riley refused to give her money to this defendant, and the defendant attacked her. The defendant began striking Miss Riley repeatedly with a closed fist and then slammed Miss Riley's head into the wall. Upon officers' arrival, they observed severe swelling to Miss Riley's head as well as a busted lip. And due to the severity of Miss Riley's injury, she was transported to Emory Hospital. Your Honor, due to the violent nature of this offense and the fact that it occurred yesterday, the state does have concerns for Miss Riley's safety, and thus we are asking for no further contact. So the state's recommendation in this case is a $3,500 surety bond, no further contact with Miss Lisa Riley, and a stay away order from the Imperial Hotel located at 355 Peachtree Street Northeast.
All right. PD Kim.
Yes, Your Honor. Miss Williams is actually 34 years old. She was born in Mississippi. However, she came here, I guess it was Michigan, I'm sorry. She came here a while ago. Your Honor, we would like to request for a signature on bond. However, if Your Honor is not inclined to give her a signature on bond, we would like to request for $1,000 good bond. We have no objection to stay away or no further contact with Miss Lisa Riley since they do not know each other. They have no relationships. And Miss Williams indeed completed and got a bachelor's degree. I am actually asking social worker services to go out and help her with her housing resources as well. Thank you.
All right. I will order a $2,000 surety bond. I will order the stay away from the Imperial Hotel, 355 Peachtree, no further contact with the victim, Lisa Riley. No drugs, alcohol, or weapons while on bond. All right.
Thanks, Your Honor.
And now we'll go to last one's number 8. Are we still going into breakout with 8?
Yes, Your Honor.
All right, PD Kim.
Can I give you the history first?
Oh, I'm sorry. Yeah, I was just seeing.
Yeah, them breakouts be a little long, so let me do this. I mean, ain't nobody on here but court staff, but
Well, I know we could do it here. Maybe
Yeah.
we don't want the mental health to be recorded because we're still recording.
that's fine.
And stop the recording.
Yes, we would need.
Okay,
to-
we'll stop it and then
Yeah,
we don't
solve
have
it.
to worry about the breakout.
Okay.
Thank you.
2020, got FTA. His
How
first
many?
cycle, he has